One of the things that deeply disturbs me about this movement toward shared parenting that has been around for quite a while, this is really not a new or novel idea, is that it treats children as property to be equally divided between parents who cannot agree on the best interests of their child. There's a legal doctrine known as parens patriae, in which the court or the state has a compelling interest in the child when parents cannot or will not exercise or determine what's in their own child's best interests. It's a very old, established doctrine that assures us in society that someone looks out for the best interests of vulnerable or dependent persons, such as children are. Such is the case when parents resort to the courts for custody determinations. This subset of parents who cannot or will not agree as to what living arrangement will best suit the child after the breakup of the marriage, or for those never married, must submit to the court's decision-making. However, House Bill 1255 limits the court's discretion by creating a statutory fiction that supersedes the best interests of the child, with the notion from the get-go that in each and every case, instead, no other factors are relevant to the custody determination than the 50-50 time split. Look at Section 1, lines 8 through 11 of the bill, if you would, please. It establishes the rebuttable presumption that in each and every case, parents are to have joint physical custody of their children. As you go on to read in line 8, the burden of overcoming the presumption rests on the parent challenging the presumption. This means, because words mean something, that the court cannot, of its own motion, override this rebuttable presumption when the case is before the court. Instead, the court must wait until a parent challenges this presumption and presents evidence to the court before the court can take into consideration all of those other relevant factors about the child's life that amount to the best interests of the child. As you see, line 9, the presumption may be overcome by demonstrating that joint physical custody would not be in the best interests of the children, or by one parent waiving the presumption. This does not give the court the authority to override the presumption, because the next line tells you how the presumption must be overcome. The party challenging the presumption must overcome the presumption by the greater convincing force of the evidence. That is why House Bill 1255 limits the discretion of the court. In the beginning, the court can do nothing but hold to this presumption in the law. That's what presumptions in the law do. They take away the court's discretion. And in this case, the court cannot simply override what is in the court's mind the best interests of the child. Instead, the court has to wait until a moving party comes in to challenge and rebut with convincing evidence that presumption. This is a complete 180 degrees from where our law is today. Under this bill, Charlie Sheen has immediate physical custody half of the time of his children, and that mother must come in, must get a court date, get on the calendar, and get before the judge to bring evidence that would convince the court that he should not have those children half the time. And until she can get into court and rebut this presumption, that's the way a case like this would work under this bill.
The Senate agreed to the amendment offered by Senator